Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. This is our bi-weekly telephone call for the community. I um, Today is April 20th, 2017. I have a bunch of questions enough so that we won't have time for any new questions. But I do want to address one issue, which is Trump's executive order from day before yesterday, where he talks about changing the H-1B visa program. I have an opinion piece and what is called an op-ed on a publication called The Hill, where I addressed this issue, and my concern was that I agree that the H-1B visa program requires some modernization, but it also requires simplification and streamlining of regulations that are overly complex and processes that are very, very slow. So we need to have a change in that. I also thought that it was far from clear. People make certain assumptions that, oh, H-1B workers are bad for the economy. I think that's an assumption that needs to be very carefully examined. There are arguments on both sides. I don't have enough facts. I'm not an economist to really be definitively commenting about the economics of a visa program, but neither are these people who are making willy-nilly the decisions to change the laws overnight. So I think this needs to be very carefully studied. I pointed out in this article that you are making formulations like we want H-1B visas to go to the most skilled or the highest paid, but there are so many factors that go into worker shortage. First of all, is there a worker shortage? If there is, there's no question of highest paid. What does that even mean? Because if you already have a shortage of workers, you're not going to be able to test the labor market to see if there's anybody qualified available. So there are several things here that I pointed out. I would strongly advise you folks to read up on this article. The links are on our both LinkedIn, Facebook, as well as Twitter accounts and Google Plus. I have put links there. I will also update my blog this weekend. I think you should definitely take a look at it and keep track of the policy issues involved. And I have also commented that there are three kind of um, agency reforms that are, let's not call them reforms, three types of agency actions or legal actions that need to be worried about. Substantive rules, the rules that define things and provide you, I shouldn't call it define, rules that give you rights and benefits are called substantive rules. They are not easy to change. You have to go through the rulemaking process. Trump cannot change them overnight. Interpretive rules can be changed overnight. These are rules that merely give you interpretation. And also, policies can be changed overnight. I don't know how many of you are familiar with when the so-called Neufeld memorandum came out. Overnight, H-1B visas became so difficult because government had changed the interpretation of employer-employee relationship. So they can really do a lot of damage. And my conclusion was that you've got to be careful. You cannot really afford to tinker with the economy without knowing what you are doing. And that was my take on the H-1Bs. Once again, I would encourage you to follow the links to my article on the Hill or my op-ed opinion piece. Um, this is you can get it from our Twitter page or just go to the home page, immigration.com, and follow either LinkedIn, Facebook, or Google Plus. The link to the article are there, and I will also update my blog. Okay, anybody has any questions about the H-1B visa programs? I don't think anything is going to happen overnight, but if you have any questions about this issue that I just discussed, press *5 on your phone, and then I'll get started on the conference. Okay, all right, so let's get started with the questions that are there. We don't need this anymore. I'm also following my Twitter account. If somebody tweets to me, I will know. Let's start with the frequently asked questions first. There are certain questions I think get asked quite a lot, so I just mark them frequently asked questions. Krupa 1992 says, I-485 is approved when I'm outside the US. Travel on advance parole or green card. This is a common situation. Your 485 is pending, you've got your advance parole, and you traveled outside USA. While you are outside USA, your green card got approved. How do you enter the United States? And the answer is you can enter the USA using your advance parole. Can you also wait and get your green card delivered to you, for example, by hand, and then use that to enter the United States? And the answer is I'm not sure there is any law on that, but I know that people do it. I don't think it's forbidden, but I would feel a whole lot more comfortable if people came back on their advance parole. So even though the green card is approved, you can enter USA on advance parole. Anybody has a follow-up question on this? Press *5 on your phone. Anybody has a follow-up question? Okay. Let's talk about the H-1B 60 days grace period. First of all, certain things have become clearer. The 60-day grace period is not a right. It is something you ask the government for. So if you got unexpectedly laid off or something of that nature happened beyond your control, you can request the government when you file for an H-1 transfer that even though I was out of status for 45 days or 50 days, please give me status without having to leave USA. And once you file the application and get a receipt, you can start working. So AC-21 does protect you under this rule. Let's see what the questions are. And I think I combined two posts here. Yes, I did. I merged, I put a signal here. I have merged two posts. So, and I couldn't remember whose post I merged. Hopefully you know who it is. I may even have, yeah, this is just two merged posts. Okay, so the first set of questions was from AX341. Lost job recently. I'm trying to understand how much time I have to find another job. So really, technically, you don't have any guaranteed time to look for jobs. 60-day grace period is merely an accommodation the government might make. And of course, this is not a one-shot deal. That accommodation can be made every time you do a transfer. Is it necessary that the H-1B start date be within 60-day mark from the last day of job order? I'm not sure what that means, but if you don't file an H-1 with the USCIS within 60 days, they can and probably will make you go outside USA for visa stamping. They're not going to give it to you within the United States, most likely. An H-1B is filed when after getting the LCA, it is actually received by the USCIS. Before that, it's not filed. Actual receipt by the USCIS, when they physically receive the case, is when it is filed. When the package is received, physically received. So even if they enter it in their system 3 days later, that's not our problem. As long as the package is delivered with the right fees and the right documents, that package is filed. Then there were follow-up questions about approved I-140 and laid off. This one was said that I am on 7th year of H-1B. I-140 was approved for 4 years under EB3, laid off from the current job. Employer does not revoke. And technically, underemployment for the next 3 months is part of my severance. By the way, I want to point this out to you guys. It's impossible to pin USCIS down on the severance issue. So if you're getting your regular pay, that is definitely keeping you in status. But if you're getting severance, which is part of your departure, government, if they start questioning it, may not accept it as being in status. So there's something to keep in the back of your mind. It may not be relevant for everybody, but severance, if questioned, could fall apart because it's not regular salary. So for a moment, let's assume that it's not going to be an issue. And a lot of times they don't make an issue of it. After I find a new job within the grace period, when can I start working? I just pointed that out to you. You cannot work while the 60-day period is going on, but once your case is filed within the 60-day period, you can start working. And there's a problem there whether you should start working when the actual physical receipt comes or the papers are received by the USCIS. I don't think there's a clear answer to that question. That depends upon how aggressive you want to be. Using the valid H-1B stamp for the last employer and receipt of a pending H-1B petition, can I travel and come back? I think you can. So when an extension is pending, or yes, I see your hand. I'll get to you in 1 second. When a transfer is pending or an extension is pending, if your visa is still valid, I believe you can travel and come back. So that should not be an issue. Can you travel to Canada? Yes, I believe you can. But the only caveat is that you should not have been out of status. That's where things get a little murky. If you are out of status, can you travel and come back? I don't know the answer to that question. If you are maintaining status and you filed for an extension or a transfer within that status, you can definitely travel and come back. Can you do that if you're out of status? I don't know. I don't know the answer to that question. Anybody who has a question, press *5. One hand is already up, but anybody else has a question, you can also press *5 on this issue alone. Nothing new. You just put your hand down, actually. It works like a toggle. If you press *5 once, hand goes up. If you press it again, it goes down. Okay, you're back again. All right. California, go ahead. I can hear you. California.
Yeah. Hi, Rajiv. This is Sandeep. Thank you for sparing your time and then clearing our concerns.
My pleasure.
So my question is, I was working as a full-time job in 2016. I got laid off on March 31, 2016, and then I got another job in May 25th. I got my E-Verify done, and then everything hit I-797 process. The joining date with the new employer was May 25th. So there is a gap of like 55 days, and then they already applied for the H1 for that. And then I got 2 RFEs, and then in the RFE they are asking for what exactly I have done in the time gap. And then I gave them the pay stubs until March 31st, and then also pay stub from May 25th to rest of the year. But they are specifically asking for that time period of 55 days. When I asked about my employer, he told me that usually they will show some kind of forgiveness. USCIS, they may show overlook it, or they may forgiveness. In the worst case, they may give me a consulate visa, or there is a chance of they gonna approve it right away. But I got a second RFE on that, so I'm like little concerned during this process. I'm even scared to go with the consulate visa too. So I'm not sure what are my chances, whether there is any chance of getting denied consulate visa or approval of I-797.
Okay, let's open up this problem a little bit. First of all, there are 2 issues. One, are you allowed to work during those 55 days when the case has not yet been filed for the transfer? And the answer is no. The grace period specifically says you cannot work until the H1 is filed within the time. Then you can start working. So if you worked, you are out of status. And if you're out of status, they will make you go outside USA for visa stamping. Now, second issue, when we open up this bundle, the second issue is, what are my chances of getting a visa? And I actually was telling somebody today, my order of preference for visas these days is as follows. Easiest visas are for in-house jobs with good reputable companies. Second is in-house jobs with clear-cut project defined. Third is job at a client site with access to a client letter that explains everything, job duties, control, etc. Next level of preference is at a client, no access to a client letter, but good access to contract between the client and the prime vendor, and a job order that clearly defines everything. So that is the order. And the last one, of course, is no access to client letter, no access to projects. That would be very difficult to get a visa. Out of these, the first two, definitely in-house job with a reputable company, in-house job with a good project would be the easiest to get visas on. The third number in terms of easy would be where you have access to an end client letter. Other than that, everything is up in the air. I can't tell you how long or how easy it would be to get a visa. Okay?
And my chances are like getting approval of I-797 are like chances of getting that. Is it okay or like high chances of getting approval?
If you hang on. If you work during those 55 days, chances are close to zero. Okay.
Okay. I wasn't working.
If you were not working, I think you have a good chance because that's what the regulation is there for, right? I gotta go on to my next question. Okay. Good luck.
Okay. Thank you.
You're welcome. Okay. I have another question from Minnesota. Minnesota, go ahead, please. Minnesota. Minnesota. Area code 612. I can hear you. Okay, that must be a mistake. All right, so let's go back to the next okay. The next frequently asked question. This is also a very interesting problem. Joining an employer after green card approval. So this comes up more frequently in the context of consular processing than it does in 485. What is the problem? The problem is, let's say I am in India or China or Mexico or Philippines, wherever my country is, and my employer processed my green card through PERM. I entered the United States. Either I did not go to work for them at all, or I went to work for them just for a short while, or I went to work for them after 6 or 7 or 8 months. Out of these situations, if you did not work for that employer at all, it becomes problematic. Did you actually get your green card or not? Nobody knows the answer to this question. And my advice is to at least have some documentation that showed that you contacted the employer and they couldn't offer you a job. So that way you'll be able to keep your green card, in my opinion, because there are cases on the books where an arrangement like this has been upheld by the courts. The employee came in expecting a green card job, showed up at work, and the employer said, sorry guys, we don't have a job for you. I think you'll be okay. But if you didn't join them at all, there's some argument that you never really perfected your green card. If you join them late, depending upon how late, I think within a few months of entering, you should be okay. So there are all these different shades. If you joined them and left them after 3 months, I think you are okay. Is there a limit? I don't think there is. So this whole issue of whether I should join or not join, you should join or at least have documentation showing that you wanted to join, but they didn't have a job for you. This particular case, this is April Wilson, who says, I joined the employer 3 months after entering USA on EB3. I don't think that's a problem. Because that's a commercially reasonable time. You're coming from another country, even if it is Canada, and you came and you took some time off and there were some personal reasons. You had to take a break. I don't think it'll be a problem even for your naturalization. And not only that, you were first working for this employer, then you went to Canada, you were never out of status, then you came back and joined the same employer after 3 months, and actually you did continue working for them. No taxes were filed for the time you were no income. I don't see any problem, April. I think you'll be fine. Star 5 if you have a follow-up question on this. Star 5. Okay. Minnesota, go ahead, please. Minnesota.
Hey, Rajiv. This is another So this is regarding to the previous question. Actually, I was not able to speak that time. It was somehow muted.
Okay.
So my question is somewhat similar to the other person question. So my company like has filed an extension, and they have asked me a work schedule, what all I have done in my previous years. So I have prepared one document, like my company had asked me to facilitate them to prepare that document, like stating what all meetings and what all codings or what all I have done in last 1 year. So I have created one document in 15 days duration each period. That okay, in 15 days I have done this, and then next 15 days I have done this, and this. So is it fine? Like that it's a work schedule?
It's a little.
Because they do not have given me any specific template.
Right. It's a little unusual, but that's where lawyers come in. We don't have to have templates. We create templates. So your lawyer should be able to take care of this for you. Basically,
the problem here, yeah.
If you just follow the language of the RFE, most of these things don't have templates. As long as you get the information in there, I think you are okay. It's an unusual request. Was this a request about your work with the same employer or some other employer?
So the problem here is my company doesn't give the access to that attorney.
Okay, well, you can only do the best you can. I can understand that. Some companies don't, but you can only do the best you can. I don't think there is any, you need to worry about the template. That's what the lawyers are there for. They should review the information and put it in the proper format. Okay?
Okay, but as per your experience, Rajiv, anytime if you have encountered this kind of work schedule,
I have never had this request. No.
If you have any suggestion?
I have never had this request before. So I would have to look at the language of the RFE. I won't be able to tell you without that. Okay?
Because it was for NPT actually.
I don't know what that means.
Same Rajiv.
Okay, sorry.
That is non-proton.
Even that's non-proton. It doesn't matter if it's non-proton. The concepts are the same and the ideas are the same. So non-proton doesn't provide any specific different situation than an ordinary H1. Okay, I gotta go on to my next call. Good luck.
Yes, sure. Thank you.
You're welcome.
Thank you.
You're welcome. Guys, some of these questions are very fact-bound. It is difficult to give an abstract opinion. So I'm not sure what I can do in those cases. Joining an employer after green card approval, we're done with that. Oh yeah, this one is also a new problem that under Trump has come up, which is programmers and USCIS site visits. Let's understand what the problem with the programmer is. The issue is, government says that the title programmer contains both professional and non-professional jobs. What does that mean? The title programmer, which is just coding, can be done by somebody who's just a high school graduate or by somebody who has an associate's degree. A bachelor's degree is not required to be a programmer. So programmer analyst, these could be titles they're going to question more closely. They want us to prove, it doesn't mean they're going to deny all cases uniformly. It simply means they are going to ask us to prove that our job requires at least a bachelor's degree in computer science, information systems, math, engineering, or equivalent. So by itself, the title programmer is not an issue. I also want to point out that programmer title for green card is not a problem. But for H1, because a degree is so much a part of the basic requirements, it is become an issue, and you should be careful with that. The question here is, the designation in my current LCA has programmer word. Should I change the designation to a different one when I apply for renewal? And the answer is sure, if your job is indeed something other than programmer. See, the problem is in the IT industry, titles are very misleading. You could have somebody called a programmer, but they are doing software architecture. You could have somebody called a software architect and they're doing database architecture. So these are not really hard and fast job requirements, or sometimes you call them technology specialist, and that could be just anything at all. I think it is the job description, not I think, I know it is the job description that's the most important thing. Titles matter only as pointers. Titles are not definitive. So changing the title, yes, of course, if you can avoid the title programmer, that's a good idea. But you don't want to prevaricate, you don't want to lie about something. Then there is an issue of site visits. By the way, I may want to point out to you, this issue with programmers, this title has existed for a long time. Government used to question us. They would every now and then start questioning all the programmer cases. Then they would back off, and we were still getting approvals. It isn't like we were not getting approvals. It just becomes more difficult. So site visits, again, they are going to target consulting companies and companies who are basically off-siting their employees for site visits more than they would normally. But they were already doing that. I'm not sure there is a huge difference between yesterday and today. I think it's the same old stuff. Just make sure you are working where you are supposed to be working. You are doing the job that you're supposed to be doing at the level that you're supposed to be doing. I don't think any employee should accept. First of all, I think it's a problem if you have a consulting appointment for an entry-level job. Typically, that's not the routine. But of course, there are plenty of jobs in consulting also where entry-level consultants are okay. So if your salary is entry-level, your job should be entry-level as well. Job description should be the same as what you are actually doing, and it should reflect the level of your seniority. Next question is, my most recent H1 is via change of status from H4. I'm good till March 18. I'll be applying March 2018. I'll be applying for H1 renewal 6 months before, but just in case the renewal doesn't come through, can I apply for change of status to H4 while I'm here? Well, the problem with that is this. If you have a status pending and your old I-94 expires, you cannot convert to another status. You can try, but when the second status adjudication time arrives, if the first status is not already adjudicated, you are in between statuses. They'll ask you to go outside USA. I don't want to make it too complicated, but the bottom line is, when you have a case pending, you are okay to stay. It's called authorized period of stay. But you don't have full status if your old I-94 has expired. And that is the issue you've got to be careful with. So can I apply for change of status to H4? You will have to go outside USA. That would be the smart thing to do anyway. Can I stay beyond the I-94 with the AOS receipt? Absolutely. Not AOS. AOS is 485. So when you have filed a case within the time permitted for the first case, still in status, and you have a second case pending, you can continue to stay in the United States. Like I said, this is called authorized period of stay. How long does this process take? I am not sure I can answer that question. Then there's a whole lot of details about senior program analyst. I'm not sure if the occupational title and job titles are different. So this is, I think I might have merged these both. Yes, this is a next set of questions is from Ramaya. The first set of questions was from SDDS. So now I'm going to Ramaya's questions, which are my present I-140 is code 15 this, title is computer systems analyst, senior systems analyst. That's the internal title, I guess. I'm not sure what occupational title and job titles are different. I don't know what that means. My I-140 is approved in 2013. I want to change jobs. I read the title about computer programmer. Will not have much scope in the USA. I already described that to you. For a green card, that's much lesser of a problem. What is the best approach to file a green card again? See, because you are only doing an I-140 port over of the priority date, You can have any job title, and job title should be honest. It should reflect what the company's position in this is. You shouldn't tailor make your job descriptions or job titles. Of course, we have to make sure that the presentation is appropriate, but we cannot make up things. So, and I'm not worried about the title of a programmer, especially in the context of a green card. But if you're doing work which is more systems analysis, you want to reconsider that. But if you're doing work that involves software engineering, software developer is the better title. So a lot depends. Your lawyer should be able to tell you, especially if they understand technology, they should be able to tell you what is the appropriate title and job description. And then the employer can basically take that as a template and describe their own job. Should they keep the same designation? No, you're not bound to the same designation. You can completely change the designations. When you are doing I-485 portability, you are porting your whole green card over and not starting all over again. Jobs have to be same or similar. But when you are just taking the priority date, which is based upon the I-140 approval, you can have a completely different job. It is no issue at all. You can be a project manager, a software development manager, a CEO, we don't care. You'll still be able to carry your priority date. Jobs do not have to be same or similar. I think I've answered all your questions. You have any other questions? Anybody has a follow-up question? *5. Follow-up question on what I just discussed. Press *5 on your phone. Okay, I'm going to Texas. Texas, go ahead, please. Texas.
Hello, Rajiv. Thank you for doing this call.
Sure.
So I have a quick question on the first set of questions that you answered with regard to the programmer in the LCA designation. So for the last couple of H1s that I got, the designation was programmer analyst. Now, when I go for the next renewal, if I change it to something more relevant to what I'm currently doing, is that going to be an issue when it reaches USCIS? Will they point out, hey, why did you change the designation? Will there be any sort of questions from USCIS?
I do not think that change in job titles is a red flag of any kind. My approach is always to be truthful. And if you are truthfully varying from a particular position that you had taken earlier, I'm not concerned about it. Okay?
Okay.
All right.
Thank you. And the second question with regard to these visits. So basically, between my employer and the end client, I have a vendor. So I know you answered it earlier. So it's nothing unusual, right? I mean, even if there is going to be a visit, if I just present what I'm currently doing, that should still be good. Or is that something that I need to keep in mind or worry about?
I'm not sure what you are asking me. I'm not sure what you are asking me. But the bottom line is this.
I'm not quite clear.
Hang on. Let me finish. Give me a minute. Because I've got a bunch of people. I've got 4 hands up already. I've got a bunch of people to answer. So let's just keep it short. Ultimately, your lawyers will have to decide what they want to do. But what happens is, government says, and I personally think it's basically an excuse. Government says that they want to see something coming from the end client. I don't care if you have 16 layers of subcontractors. If you can get material, including either letters or contracts or work orders, coming from the end client, that describes certain things about your job and you are fine. But if you cannot get that, your case it's a toss of a coin. I don't know which way it's going to go. Okay? I got to take my next call.
Thank you. I do have end client letters.
Good. That's very important. Okay. I am going to go to, let's see, this one. I can't tell which is this. Let's see. Let's go to, we are in Iowa. Iowa, go ahead, please.
Hi, Rajiv. I have a quick question. So regarding the USCIS client visit, the address on my LCA is the client office address, but currently I'm working from home, which is within the same MSA. It's like 8 miles from my client's office.
Hang on. Don't I have a question from you? I remember your question. I think I have a question. Did you post something? Did you email me or did you post something?
Yes, I did post something. It's
Okay.
similar,
Yeah.
it's
So,
regarding that.
so that's a difficult question to decide. I know your problem. Basically, the LCA is an appropriate place, but you're working from home, which is only 8 miles away, right?
Mhm.
Okay. Now,
And,
I
and
don't
it's the
think,
same.
and it's the same MSA. I don't think that's a problem. There may be a, let's call it a logistical issue. Where are you working from? And by the way, if government comes to visit and you are not there, they're not going to do anything precipitous. They'll just send you your employer a notice saying we went and we saw and we didn't find him. We are going to revoke the H1 unless you can explain what happened here. So there are a couple of ways you can forestall that. An amendment is not necessary in my opinion. But I think it may be a good idea to file an LCA for the home location also. So what you can do is you can add another LCA for the home location. That way, when government goes to the Department of Labor data, they can find where you work, those two places.
Okay.
And now they may not look for it, but if there is an RFE or a notice of intent to revoke, you can show the LCA saying, hey man, you should have looked at the LCA. You should have looked at the Department of Labor data. It's already on the record that he's working from two different places.
Okay. Okay.
Right.
I was just concerned because
No.
there was also a memo USCIS which says if it's within the same MSA, there's no need to file new LCA.
That memo is actually defective. But nevertheless, don't worry about too much. Your situation is straightforward.
Okay, just file a new LCA.
I think LCA covering your home location will take care of this problem.
Okay, thanks.
Good luck. Okay, we got two more hands. Let's go to we are in Louisiana. Louisiana, go ahead, please. Louisiana.
Hey, Rajiv, I really appreciate doing this one. I have a question, something related to what you just answered previously. This is my fifth year in H1, and my current I-94 is expiring in June 31st of in next 2 months. So my company has applied for an H1 at premium before April 3rd, and we got an RFE. And my company responded to the RFE day before yesterday. So it's going to be processed in premium. My question is my wife's due date is on end of June, the same day my current I-94 expires. If in case the worst come the worst case, I have my I-140 approved. If in case the worst case my H1 extension got denied for some reason, and I cannot travel back to India because my wife's right on the edge of the delivery. So what are my options if in case my H1 got denied, extension got denied?
Well, I think I would have you apply for a B2 visa, but I would have you leave within 180 days of the denial. This is a very generic answer. Just keep this option in mind and discuss it with your lawyers specifically how it applies to your situation. So tourist visa to buy you 4, 5, 6 months of time. Okay?
Okay. Okay, well, but why doesn't have a tourist visa here? I have my business visa.
No. You will actually. I'm making it in my hurry to make my communication understood. I'm being inaccurate. You're asking for tourist status, not visa. So you're asking for status, okay, and you can apply for your wife as well. She does not need to have a stamp on her passport.
Okay, all right. So for the new baby who's getting born, I will not have any place in your issue in applying a passport or OCA or something like that, right?
Of course,
I should be able to.
The child born in USA is a child who is natural US citizen by birth. Okay.
Okay.
Good luck.
All right. Thanks, Rajiv.
Oh, you're welcome. And congratulations.
Oh, thank you.
Bye-bye. Okay, so the last question in this series is from Alabama. Alabama, go ahead. Alabama.
Rajivji, good afternoon. I have a similar kind of situation what Ramya was explaining. I have 17 years of experience and I work as a senior manager and I'm planning to join client. So, but they told me that they want to take me as a senior software engineer because they don't have lots of hierarchy. So I agreed, but I requested them, can you give me an offer letter, similar kind of designation? So let's say after 2 years, if I change the job, then it should not affect my career. So those all things they were fine, but now for green card, they asked me like whether I have to keep um, senior project manager as a designation or I have to keep senior software engineer because my present LCA is also posted into same occupational code 15-11.
Okay, hang on, sir. Let me stop you for a second. I am not going to be able to give you an answer, but I can give you the guideline. The guideline is when you are just taking the priority date over to another employer, you don't have to have same or similar jobs. They can be totally different. When you are going from H1 to green card, you can also have different jobs. Please don't make up titles. Please don't make up job descriptions. Whatever is the truth, use that. Those are the guidelines I'm going to give you, nothing else. Rest is up to your lawyers. Okay?
Okay, thank you.
You're welcome. Good luck. Okay, guys, we can only go this far. Beyond that, it will be like diagnosing a patient without looking at a patient. Let your lawyers help you out. That's what they are there for. But I can give you what the legal rules are. Georgia, go ahead. Your name is familiar. I think you were a client of ours, weren't you?
Oh, long back.
Yes, I remember your name. How are you?
I'm good. Yeah, this is maybe not related to that question. I have a question on number 3. So I was just waiting. So I just want to pitch in. So just you want me to wait and I can wait. I don't know whether it's the right time.
Well, since I don't have a whole lot of time, I just want to finish up anything that I can. Go ahead and ask your question.
Yeah, that's what I hear when you say last question. So that's why you raised in my head. So it's regarding my daughter. It's number 3. Question number 3, Baldwin 3.
Give me 1 second. Let me scroll over to that question. 1 second. Let's see. Question number 3. Is that the one that says Baldwin?
Yes, Baldwin 3.
So it says basically they got their green card. First of all, I am not sure what the lawyer was thinking, because under CSPA, Child Status Protection Act, the time the I-140 was pending, it's subtracted from the age of the individual. So your daughter should have been able to get her I-485. There was only 1 day gap. I don't know what happened here.
Right. First it was in EB3 in 2008.
It doesn't matter. It does. Well, if the 485 was current, if the 485 dates were not current, then I can understand. Now, the question is, can the parents apply for me? The answer is yes, as long as she stays unmarried. Okay. The only issue I have is, let me explain one thing to you. The only issue I have is when somebody is on F1 and a green card is applied for, they can have trouble getting their travel, etc. authorized. So I'm just a little concerned about that part. Once she's on H1, just look at the times. How much time is it taking for that unmarried child of or unmarried adult son or daughter of a green card holder? Just see how much time it is taking. I think it's about 3.5 years, something like that. Take a look at that, and if the time is okay, then go ahead. Once she gets her H1, then there is no problem. Green card can be pending. Okay.
So my question is this one: like, if I file for I-130, does she's going to get the priority date of my
no.
EB?
No.
No. Okay.
Her priority date would be the date you file the case.
Oh, the one I-130, right?
I-130, right? Because she's not going through. She's not going through employment-based case. That is gone. She is going through as a relative case.
Yeah.
Okay.
Yeah. So if she files 130, I-130, I mean, I file I-130, and again she got her H-1, and once she's ready to file labor and all the stuff, that she's going to get the
It's no problem.
priority date of
No,
I-130?
no. You can't carry the priority date
No? Okay.
from the relative-based petition to employment-based, but she can file green cards to as many categories as she likes.
Okay.
Okay.
Thank you, Rajivji.
You're
Yeah,
welcome.
after like 16 years, I got recently, 3 weeks back, I got my green card. So I've been on H1 for 16 years. So I contacted you several times.
Yeah.
Even I got
No, I remember your name. I remember your name. So good luck. Good luck. Good to hear.
Thank you. Thank you very much.
You're welcome.
I appreciate that.
My pleasure. Bye-bye.
Thank you.
Okay. So let's go on to the next frequently asked question. We did the grace period. We did this one also. Programmer title. We did that. Then let's see. Wow, that's a long one. I got a couple of merged posts here. Here are a couple of frequently asked questions. The first one is easy. Can I get unemployment payments on H-1B? Yes, you can. But there's one problem. Getting unemployment payments is not an issue because unemployment is private insurance. It's not really government funding. The problem is that doesn't protect your status. So don't think that if you're getting unemployment payments, you are in status. You're not. So it's like a chicken and, well, it's a tautological, it's a circular problem. Because even though I'm getting my unemployment payments, I'm not in status, so I have a problem. So to answer your question, unemployment, sure, no problem, but it doesn't give you status. Star 5 if you have a follow-up question on this. Star 5. Two people have follow-up questions. Let's go first to California. California, go ahead, please. 3 people have questions. California, go ahead.
So this is the person who asked the question about the unemployment payment.
Right.
I understand I'm in the grace period, and if I'm, I may find a job or start working on a job in a few weeks when I find one. So is the unemployment payment going to impact me negatively at any point in future related to my status or green card? I don't know that part.
They will not affect you negatively. No, sir. Okay?
Okay.
Good luck.
All right.
All right, let's go to the next one. This one is also from California. California, go ahead, please. California.
Hello, Rajiv.
Hello, sir. Go ahead. Yeah.
First of all, very congratulations for your 24 years of milestone completion.
Oh, thank you. Appreciate it. Actually, it's a little bit more than that, but okay. 24 years is okay. That's not bad.
Yeah. And thank you for your service for contribution for the society.
Of course.
My question is actually it's a big long question, and it's immigration related question. If you can, I can explain it like.
I have a problem. Hang on 1 second. Look, I have a problem. I'm not doing any new questions today. Unless your question relates to something I'm discussing, I won't be able to deal with it. You can send me an email.
Right.
I'll do my best to answer whatever I can. Send me an email, and if necessary, I'll post it for the next week's conference call. But I won't be able to take any new questions today. I have a lot on my plate already.
It is right. It is not a new question. It is related to this conference call, sir.
Okay.
I have posted my question. 20th May 2016 is the interview date, starting with that title.
Do you know the question number? Hang on 1 second.
Right.
What did you say? What is the title you said?
It's a 20 May 2016 interview date, and my name is Monarch.
Oh, I know who you are. You called me from India some time ago, didn't you?
Yes, I just called from India.
Yeah, I remember you.
Yeah,
I
thank
know
you.
who you are, and I know what your question is. Well, the 864 question. Okay, now I do want people to wait for their turn and not do it out of turn. Um, I think
Okay.
it's unfair. I will definitely deal with your question. So just sit tight. If you have posted your question, I will definitely deal with it. Don't worry about it. Okay. So just wait tight.
Okay, sure.
Wait for a little while, and then we'll take it from there. Okay.
Okay, sorry.
No problem. Last one also from California. California, go ahead, please. California.
Hi Rajivji, this is Rupa.
Yes, sir. How are you?
It was my first. Thank you. It is a question related to the question number 4. And actually, my wife is in India, and her green card is approved, and her AP is valid up to another 6 months.
Right.
Can she come anytime within the 6 months, or she should come immediately?
Anytime within the next 6 months. Until her advance parole is valid, I prefer that she travel on that. I'm always hesitant about telling people, okay, you can travel on the green card that was brought to you later by a friend or somebody. I think it's better to just travel during advance parole. I worry about these things. Okay.
Okay. That was my question. Thank you, sir.
You're welcome. Good luck.
Thank you.
All right. Okay. Let's see. Do we have any other frequently asked questions? I think we did one more. And then we'll get started with regular questions. So this was travel while H-4 EAD is pending. Now, guys, there are two possible situations. If somebody has applied from H1 to H4 or F1 to H4 and applied for EAD at the same time, they should not travel until the F1 or H1 to H4 status is approved. Because if you do, then you have to go apply for a visa, come back, apply for EAD all over again. If on the other hand, your H4 is approved or already you had it and EAD is pending, you are allowed to travel. Government has said we discourage it. It can cause delays in your EAD processing, but it's not illegal. And that really is the crux. We've dealt with this question several times before. Star 5 if you have a follow-up question on this. Star 5. Okay. I think this is the poster. I see you, sir. Go ahead, California. Go ahead. Today I'm popular in California. California, go ahead.
Hi. Hi, thank you so much for your service. So she has come from India. She has H4 status and she has H4 visa and everything.
Then once you apply for her EAD, if she wants to leave, she can.
Okay, thank you so much.
You're welcome. Good luck.
Thank you.
Okay, so I think we are done with this. Let's get started on the regular questions now. It took a little bit more than I had anticipated, but that's okay. So Ricky wants to know, I only have, let's say, a couple of months when I go for my visa stamping, H-1B visa stamping. Should I apply for an extension before I leave, or can I just go for the 2 months? And I think you should apply for an extension before you leave. Because I'm not at all sure that there is any law that you must have H1 validity for a certain amount of time before they'll give you a visa. You can send them an email and double check it. It's a good idea. But if you have an extension pending, I think that makes it much more convincing a case that you actually have a job to go back to and there's an extension going on. That's what I think you should do. File for an extension and travel. And if I'm not given visa at the interview, is my extension still valid? Yes. So you applied for extension, you left, they denied you the visa, you can take the extension when it comes to apply for a visa again. I don't know what the grounds of denial are. If they can be overcome, the extension is not made invalid just because the visa was denied. Okay. Star 5 if you have a follow-up question on this. Ricky, if you are here, you can press star 5. Let me see if there's any other question. In worst case scenario, what should be the, you can come back on H4 if there's a problem. I see you now. Okay. Minnesota, go ahead, please.
Hey, Rajiv. I just posted this question. I'm Kieran.
Sorry. Oh, what happened?
I think after that I've got answers.
Oh, okay. Okay. Good.
Here.
All right. Sorry. All right. Bye bye. I wasn't sure what happened. Then next question is from Baldwin. Oh yeah. We already did that. That was from our old client. Then this is from Jiva8204. I'm working on H1B on EBC model. I want for, oh, this is the guy who was 8 miles from the office of the client, and I already dealt with this. Good. Then, did we do this? Yes, we did this. Then we did this one too. Where is that question? Oh yeah, this is the one for you, Monarchji. You see, the question, the problem with I-864 issues is they are pretty complex. So when you get a 684 kind of problem, we have to look at a whole bunch of different things. You said option A is documentation of assets claimed, or option B, new joint sponsor. Definitely, they are both good options. Okay, they are both good options, but I'm not sure what your questions are. Following are my questions. CSPA child is eligible to enter the USA if admin processing is more than a year long. I'm sorry, Manojji, I would have to look at the law. I don't know what the implications of delayed adjudication on CSPA are. I can make a guess, but a guess is not law. So I think that'll be okay. That's my best guess. I'll be surprised if it is not okay, because what is required is that the child is under 21 on the dates become current, and you did something to follow through on getting the green card, which is whatever, whether it is filing for the residual forms like I-864, etc., or whether you filed an I-824. There are various things you can do. So if the child is already protected under CSPA, the fact that the admin processing is taking a long time shouldn't be a problem, my guess. Do we need to resubmit visa fees? I don't know of any law that requires you to do that. But always double check, send an email to the consulate, send an email to the National Visa Center, NVC. I don't think it will be required. We've gone through option A, but do we need to go with both? No. As long as you've got things covered, if I remember correctly, one of the laws is you can use your assets if they can be readily converted to cash. So if you have cash in the bank, or if you have stocks and bonds, things like that, it might be easier to prove that you yourself can pay for yourself. What is the best way to follow up on admin processing? You've tried LegalNet. Yeah, LegalNet is a good idea. But LegalNet basically goes to Washington, D.C. And you can also, I don't know who your sponsoring family member is, they can contact their congressman's office, and they can get you all these answers through the inside sources, which is probably a better idea. And again, I'm not going to comment about CSPA. That's just too complicated a determination to tell you definitively whether or not the child is going to qualify. So I'm going to have to ask you not to ask me that question in the hypothetical. I can tell you the general rules. The amount of time the IR-130 was pending generally is deducted from the age. So if the child is still under 21 when the visa dates become current, you must have done something to get the visa dates or to get the green card process rolling, whether it is filing for the fees that came to you. That's one particular example. This is what I remember. But beyond that, I would have to look at the law to answer all your questions. *5, Manojji, if you have a follow-up question that I can answer. Okay, let's see. This is... Okay, you are calling from a California number, Manojji. Go ahead.
Yes. Sir, our situation is like a bit of complex. As we faced a retrogression phase in our visa situation, we had an interview on 20th May 2016, and on that day we received from consulate that you have to submit both. You have to submit either asset proof or co-sponsor, joint sponsor. And on 9th of June, we submitted the documents of asset. And meanwhile, our file retrograded. I mean, they moved back to 2001. And when it became current on January 6, 2017. So, Child Status Protection Act and retrogradation, I don't know legally what delays can be affected due to that retrogradation.
1 second, Manalji, if you take out the time the I-130 was pending, is the child still, does the child still have a problem with 21 years of age from the date of retrogradation? Because I don't remember what the law on this is. There are so many little rules and sub-rules, because we deal with mostly these in the employment context, and that's relatively simple. So I don't really know what the law is off the top of my head. So I'm not going to be able to help you with that question. I would recommend that you can go through your congressman's office. Your family member who sponsored you can get these answers for you without you having to pay a lawyer to get them for you. Okay?
Right. And we recently sent an email to embassy for administrative processing. It's been more than 3 months. I mean, we received a letter on 3rd of January. And this is like more than 60 days in administrative processing. Is it? And we are in a worry that 20th May 2017 will be a 1-year completion of our visa interview date. Will be 1 year old. So do we need to take action on the option B if to make double check that we are good?
Well, I think option B is usually the easiest one, because going in, you know if your joint sponsor qualifies. Everything else, using your own assets, is basically a judgment call. But if you have a joint sponsor, by all means use him. Okay.
Right. So sending an additional sponsor during the time of administrative processing, is it a good advice to send some documents?
I don't see why not. Why not? They'll accept it.
So is it, I mean, we should work on that part B to submit joint sponsor documents while our case is under administrative processing for more than 90 days, I believe.
I don't see any reason. I don't see any reason not to. Okay?
Okay.
Good luck, sir.
Okay, thank you.
You're welcome. Okay, I've got 2 more hands up and I'm not sure what that is all about. Folks, if you have a follow-up question, only then raise your hand. We're not answering new questions. I'm not sure what's going on. Okay, let's just go ahead and try this. Minnesota, go ahead, Minnesota.
Hey, Raju, I have 2 follow-up questions from my previous question, if I can ask now.
I would really like it if you consolidate your questions instead of giving them to me piecemeal, because I have to keep flipping between questions. That's very complicated. Because I'm in the middle of, I'll never be able to finish my calls that way. In future, everybody, please consolidate your questions. If there are still residuary questions, maybe postpone to the next call, because I do have a lot of other people waiting as well. So go ahead and finish it up. I'll do this for you.
Sure. That's the first question in the blog. So the first follow-up question is that if she's denied her stamping and if she gets her H-1 extension approved.
First of all, hang on. Which question are you, sir?
First question.
Huh?
First question.
Give me 1 second, because I don't know what we're talking about. While the H-1 extension is pending and you only got 2 months left. Okay, got it. Go ahead.
So if she's not given H-1 stamping on the current visa and if her extension is approved, she still needs to go for stamping and come through the port of entry. So she then needs a valid job, right?
You cannot enter USA on an H-1 if you don't have a valid job.
H-1 extension, yeah. So if she waits till H-1 extension, there's a possibility that she may lose her job.
You can't enter. Then better to just take an H-4 visa and come.
apply for H1 because she's no more under cap?
Yes, once she enters USA on H4, she can, if she gets a job, apply for H1, and she would not be subject to the quota because she has H1 already.
That's all my two questions. Thanks.
Good luck.
Thank you.
Okay, one more question came from California. Yeah, California, go ahead, please.
Rajiv, this is about the CSPA follow-up question. When the child reaches more than 21 years, whether they become still partial dependent or it is fully dependent? It is a column in the form actually.
I think CSPA applies as long as they're not married. I could be wrong. I am not an expert on CSPA. I have to look up the law every time because we deal with CSPA relatively infrequently. If I remember correctly, dependent or independent does not matter.
No, because in the form I-134 there is two options how to declare whether they're fully dependent or partially dependent. I don't know what is the meaning of partially or fully.
I-134. Do they have a job?
No.
Then yeah, they're fully dependent.
They have a job. They have a job in India, not here.
I don't know. If I were you, who are you submitting the I-134 to? Is it for a visa for her or him?
No, it is the I-485 adjustment of status.
But they are in India, you said. How can you file 485?
No, they are now here on B1 visa.
Yeah, but they don't have a job here, right? So they are fully dependent upon you.
They don't have a job.
My guess would be fully dependent.
Okay.
But one thing, hang on. You should talk with your lawyers. I'm not sure converting from B1 to 485 AOS is a good idea. Make sure there is no question of preconceived intent. That could be a problem. Because you can't enter on a tourist visa to adjust to green card. They can consider that to be fraud.
She came up for a specific purpose, and that is declared in the port of entry. That is, she came for a medical examination.
Yeah, but that is the problem. If you come for a medical examination, you are not supposed to adjust status. Please make sure that part is okay. I don't have time to deal with it right now, but that's something you need to have looked at very carefully. Talk to your lawyers. Don't just file 485. It could become a problem for her. Okay?
Okay.
You can't enter to just file adjustment of status. Good luck.
Okay. Thank you.
You're welcome. Yeah, and guys, I can't really help you fill forms. That's really not a fair question, because what happens is if you help somebody fill the forms, then you have to sign the form. If you look at the language of the USCIS forms, it tells you if somebody helped you prepare the form, they should be signing here. So you can ask me generic questions, but you can't ask me questions on how to fill forms. Okay, let's see. We are now at question number 15, boy. I'm working with company A. This is pile 786. Company A. H1B is valid till 2019. SOW till April 2018. Planning to join company B, who's my client. They've already transferred my H1B visa, which is good till 2020. I want to go for visa stamping. Do you think it's not a good time to go for visas? Look, if you're working for an end client and you're getting a in other words, if you're working in-house, which is what you will be doing, I think visa stamping should be relatively simple. And you can use the same visa stamping if you change companies. Consulate has said you shouldn't do that. I don't think they can stop you from, because Foreign Affairs Manual clearly says you can do that. Will it be better if I join company B client? Yeah, I think so, because getting a H1 stamping through an in-house employment is a lot easier. Star 5 if you have a follow-up question. Star 5. Okay. Oh, here's the last question. Good. My father-in-law came here on a valid visitor visa. They did not stamp his passport with entry or exit date. I'm not sure what the process is, but here's what I would recommend. Remember, the agency responsible for this is Customs and Border Protection. So go to CBP, cbp.gov website, see if there's a frequently asked question on it. If it clearly covers your situation, great. If not, just go to the CBP office locally and find out from them what their process is. Make a note of what they say, the date and the time you went, and what they told you. You should be well protected. I'm not worried about it. All right, folks, star 5 on this follow-up question, last one. Okay, very good. I will see you guys again in 2 weeks. Thank you for being here, and I appreciate the opportunity to be of assistance. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.